Chapter 11, Real Estate Contracts. Now, this chapter is going to talk about general contract laws and concepts. A lot of questions from exams coming from it, as well as the last chapter, chapter 10. We had a couple questions from exams, but this chapter 11 is going to have a boatload of questions coming from it too. Contracts. Because it does also talk about a lot of topics that we've already gone over in earlier chapters too. But it's going to also talk about some new concepts and contract law. It's going to talk about general contract law before it starts delving into real estate and real estate contracts. Remember, we have to follow not just contract law, we need to follow real estate licensing law. And there's various laws we need to go over, and that's what we're going to do now in this chapter. So in this chapter, you're going to describe the essential elements of a valid contract, including the effects of the statute of frauds, and we're going to learn what the statute of frauds even means and what it is. Even though we learned that that usually has to deal with something being in writing to prevent fraud. We're going to identify different types of contracts and issues that affect validity of contracts. And we're going to learn about the differences of what actually makes a contract valid. We're going to explain various contracts that are used in the real estate business and which ones we can and cannot use and what kind of properties we can and cannot prepare contracts for, even though we went over that in like chapter 2. You guys recall what kind of properties we could prepare contracts for?
My brain.
Residential, 1 to 4 families and single buildable lots. Everything else is considered commercial, and those contracts need to be prepared by attorneys. We can market those properties for sale, but we cannot actually prepare the contracts for them. Same thing with contracts that have option agreements. Option contracts, like a lease with an option to buy, attorneys need to draw up option contracts. All right, so we're going to learn about that stuff in this chapter as well. So what is a contract? It's a voluntary agreement between legally competent parties to perform or refrain from performing some legal act. And it has to be supported by legal consideration to be valid. Any contract, in order to be valid, both parties need to be giving up something. And there has to be something given in exchange between the parties as something of value in order for a contract to be enforceable. If you guys ever watch any of these Judge Judy type programs on TV these days that were...
oh my God, I'm obsessed with Judge Judy.
I am too. I am too. I love it.
Episodes every week now.
Yep.
Well, there's also that other one. There's that... that younger lady, she's younger, I don't know, compared to some of those judges you see on TV. She's pretty Spanish lady. You see her on she's common sense, and she's straight to the core of the issue. Sometimes she yells a little bit, but
I forgot her name. I see her face, but I can't call her name.
But yeah, I was watching her yesterday during lunch hour, I think it was, and she was talking to somebody, explaining to them. You had one lady suing her best friend because her best friend agreed to give her the guest house to live in or something like that. And then she was looking at Gift Horse in the Mouth. She was like, well, she broke a contract with me because her daughter went and got divorced and they had problems in their family or whatever. And now she's reneging on giving me that guest house. It's like, well, yeah, but didn't she give you another place to live in the house and she was going to make up for it and all this? And she's like, yeah, but I don't want that. I want the guest house. And she's like, well, don't we all? I'm like, it's a gift. You're looking at Gift Horse in the mouth, and a gift is not a contract. Now, if you were to maybe cancel something or put storage up, or it cost you money because you relied on something that she may have promised to you, well, then we could talk about that a little bit. But this isn't the case. She gave you something, and then a family emergency came up. She's got to take care of her daughter, who went through an unfortunate divorce and had to get out, and she had to put her daughter up somewhere. And she's not leaving you high and dry. She's giving you a place too, but it's not good enough for you, that gift that she's giving you. So what a contract is, a contract is where both parties are giving up something. You're not giving up anything. You just want something better. A contract, both parties give up something in the exchange, and there has to be an exchange of something of value between the parties. So you can't sue her for this. That was I should have recorded that, because that's an excellent explanation for what we're coming to right here. But I guess I did a good job in it. So a contract may be defined as a voluntary agreement between legally competent parties to perform or refrain from performing some legal act that is supported by legal consideration. That's the compensation that one gives or receives from another. That's on page 193 at the bottom of the page, the first page of the chapter. All right. There are 4 essential elements for any contract to be valid, whether it's a real estate contract or an employment agreement. And they are competent parties. You have to have competent parties to the contract. Offer and acceptance. Somebody has to make an offer and somebody has to accept the contract. There has to be some form of something of value exchanged between the parties. That's what consideration is. And we're going to go over the 3 different kinds of legal consideration. And then there has to be the purpose of the contract cannot be against public policy. It has to be for a legal purpose, or the object that's being transferred or exchanged. If the contract is based on not a service but an object, it has to be a legal object. Can't have a legally enforceable valid contract enforceable in a court of law to sell crack, because crack is whack. It's illegal. Controlled substance, right? So you can't have it, so the legality of the object or purpose of the contract has to be valid. It can't be against the law. It can't be against public policy. You can't have a legally enforceable contract to murder somebody, because murder is illegal. It's just the basics. All right. So in the book on the next page, 194, let's write the number 4 down first, and then we're going to highlight essential elements of a valid contract. And then just highlight the titles of all these things: competent parties, offer and acceptance, consideration, what the 3 legal forms of consideration are, the legality of the object, and then highlight this sentence about the parole evidence. So competent parties, to enter into a binding contract in New Jersey, you have to be a competent party. What is a competent party? That means you're at least 18 years of age and of sound mind. It does say in the book that a married person under 18 is considered an adult. We got a problem with that.
Under 18?
You can't get married under 18 years of age in New Jersey, even with parental consent anymore. In the past, you could get married at the age of, I think it was 16, I think was the youngest you could get married with parental consent, but no more. See, a lot of things that a lot of people don't realize is that when Trump was president, he did a lot of stuff to protect children and against human trafficking, which is a major issue in the world. It's basically slavery, human slavery. Human trafficking, that's what it is. It's modern day slavery. And you're seeing this, it still goes on in the world. And the United States is a huge consumer of these modern day slavery, human trafficking. So what's going on is you had so many people that were using children for prostitution and other things like that. They traffic them in, they use them. Just check with Jeffrey Epstein, right? You could see the rich and elites are not exempt from that either. But they distance themselves, and they're not too quick to enforce laws against those things because they partake from time to time themselves. So It's sick, it's disgusting, and sometimes people's parents, the actual children's parents, get involved in this, especially since we're a melting pot and we get people from all other countries that come here that are not so quick to accept our culture and our laws, and they want to do their own thing here. So in some countries, in some cultures, it's acceptable for a 50, 60, 70-year-old man to marry an 8-year-old girl and then consummate that marriage. That's disgusting. That's child abuse. Okay. So you're even seeing that happening here in the United States. Okay. But not legally at those ages. But you could see parents selling off their children to others, and the way that they do it to not be in violation of the law is they give parental consent. But Trump was going after a lot of these websites that were enabling the human trafficking and the prostitution stuff that held them personally responsible. That even though they were not engaging in the human trafficking aspect, they were enabling it through their platforms. So he said that if any of these platforms are getting involved in allowing this to happen on their network and they catch human traffickers, they will be held, those platforms will be held responsible and just as liable criminally as well. That's when you started seeing Craigslist and all these other websites that had these areas where you can have dating and selling massage services and stuff like that. They disappeared from websites, if you noticed. And that's because a lot of that stuff was prostitution and human trafficking. But that was Trump's doing. That's why that went away. And at the same time, there were child protection activist groups that were operating here in the state of New Jersey that managed to get laws passed that children can no longer be married even with parental consent under the age of 18.
Good.
It's not allowed anymore in the state of New Jersey. So despite what the book says here, and despite what you may see on exam talking about this, I keep bringing it up to PSI and the Real Estate Commission, and they keep acting like they're clueless, like they don't know what I'm talking about. But I'm telling them they got questions about this stuff, and it's still in these books, and it's advertised this way, but it is wrong. Married persons, first of all, you can't be married in New Jersey under the age of 18. So, period, right off the bat, you're not considered an adult under any circumstance, if you're not at least 18 years of age. But for exam purposes, I want you guys to study now. If you are under 18 and you are married, the contract will be considered valid. This is only for exam purposes. As a matter of fact, let me just change to the next slide where I explain this. If you got to be at least 18 years of age or older in New Jersey to be considered an adult. You got to be of sound mind, sane, sober adults with no mental disease or defect that are of legal age, 18. But if you're under 18, a contract is voidable. It's only voidable by the minor, not by the adult. Anybody can enter into a contract with a minor. And that contract, the minor could just say, I don't want to be in it. And because they don't want to be in it, you cannot legally enforce a contract against a minor because they're not of legal age. They're not considered a competent party. Now, the book is saying that if they're married and under 18, they can be considered an adult and a competent party. And that is what you're going to study for exam purposes only, but not in real life. In real life, that's not the case. And that hasn't been the case since this law was passed under the Trump administration. But this is something that's a New Jersey law. But that's when it happened. So for exam purposes only, not in real life, because the laws have changed to protect minors, the exams have not yet been updated to reflect that. Under no circumstances can a minor be considered an adult in New Jersey any longer. But because the exams have not been updated for that, look here, I'll even click on it right here. I have a link to this. Let's click on the link just to prove it that it's not just me saying this. Here's a legal website, Find Law, where they discuss all kinds of legal issues. New Jersey marriage age requirements. Prior to 2018, New Jersey couples were permitted to get married as young as 16 with parental consent, while minors younger than 16 were permitted to get married with the approval of a court. But in June 2018, New Jersey became one of the first states to ban child marriages. That even sounds wrong, doesn't it? Child marriage. You know, we were one of the first states to ban child marriages, and now it's there's a clear minimum age of 18 without any exceptions whatsoever. All right. So under no circumstances can you be considered an adult, even under the age of 18. But for exam purposes, because I'm pretty sure PSI did not fix this, because they still look at me like I got 3 heads when I bring it up to them. And the Real Estate Commission is like, oh, we don't know what's on exam. Well, I'm telling you. So they're not doing anything about it either. But if you see a question about this on exam, a minor under the age of 18 can get married with parental consent. That's the old rule, and would be considered an adult. So any contracts that are signed by a married minor is legally binding and enforceable against the minor. That's what you need to study for exams, even though it's not true anymore. Okay? I guess another reason why instructor-led courses are better, we point out sometimes we have knowledge about things that the book manufacturers and even the other people conveying these messages are unaware of. All right, now offer and acceptance. When mutual assent is also, offer acceptance is also known as mutual assent. And that's when that's when the parties are in agreement on all the terms of the contract. It's said that they've come to a meeting of the minds. Okay, we're both here. We're on the same wavelength, you know. When we're aware of all the major key points and issues of a contract, and we're in agreement on all those key points, it's said that we've come to a meeting of the minds. That's offer and acceptance, okay, or that's mutual assent. Now, offer and acceptance is the parties are aware of and in agreement on all those terms which are clearly stated and understood between the parties. So for school exam, the definition and meeting of the minds is when the parties are in agreement on price, down payment, and how you're coming up with the rest of the cash, the financing method. For state exam, it's the wider definition. It's when the parties are in agreement on all the terms of the contract, period. Okay. School exam focuses more on the financing aspect of it, when you're price, down payment, and financing method. State exam, the wider definition. But either way, any contract, somebody has to make you an offer and somebody needs to accept it before you can get into a contract, right? You have to accept those terms and be aware of them. Consideration is what the parties give or receive from each other in the exchange. It's the entire purchase price. For any contract to be valid, whether in real estate or not, there has to be something of value exchanged between the parties. There are 3 legal forms of consideration. Legal tender, that's like money or a mortgage loan. An exchange of something of value, whether it's goods or services. Or love and affection. No, they're not talking about prostitution. They're talking about a family member may have love and affection for the other family member, so therefore they give a gift. Courts have determined that these gifts between relatives constitute love and affection. And love and affection is a legal form of consideration. That you can give something to your child, for instance, and you do so because you have love and affection for each other. And therefore, it is a legal form of consideration, okay? But anytime you give a gift, it should be also accompanied by an affidavit that states, in fact, that it is a gift. And then lastly, the legality or object for the purpose of the contract. It may not involve an illegal purpose or substance or object that is against the law. Whatever you're selling or doing has to be legal. It may not be against the law or public policy in order to be in in order to be an enforceable contract. So just to recap, what are the four essential elements of a valid contract? Competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. And what are the three legal forms of consideration? Legal tender, exchange of value, and love and affection, which is probably the only one you're going to remember. But you need to study all three of these, okay? The three legal forms of consideration. All right, now, the parole evidence rule states that written contracts take precedence over verbal agreements or promises, okay? So you have to have evidence, basically. It says it right there in the name. So if you got it in writing, you got your evidence. Courts will always throw out somebody's claim. If somebody has a verbal claim of something versus someone who's got it in writing and they got a contract as the evidence. Come on, you guys watch Judge Judy, what happens? Or Judge Judy type court programs that are owned by her. What happens? Hello?
I'm
Okay.
sorry. I was highlighting. What was the question again?
No,
If you go to court and you're in court and somebody has a verbal argument and they're trying to show their evidence by talking a good game and saying it verbally versus somebody who's got a contract, actual writing, which one is the court going to accept or take preference over?
The writing.
The one in writing, because they've got evidence,
Yes.
got actual firsthand evidence.
Yeah.
Sorry, my kids keep coming in my room. It's really hard to focus. I'm sorry.
Oh, they want attention too.
I know. That's why it's like so hard to focus on both. But I am trying my best to pay attention.
Okay.
It's okay.
Were they on vacation? Or are they sick or what?
No,
School's,
they're out of school.
school's
Oh,
over. Yeah, it's
Oh.
after. It's 4. Yeah, mine just came in too, but they poked their head in because I make a fake. No.
Give them a look. Just give them the look. All right. So under general contract law, a valid contract can be oral or written, but not for real estate.
No.
Real estate, when it comes to sales contracts for real estate, it always has to be in writing.
Writing.
But look, if I'm to sell you my cell phone or my laptop, can we have a verbal contract or agreement between that? Sure we can. And it's fully enforceable in a court of law. But if one person has a verbal agreement and another one got it in writing, which one will the court favor? The one in writing. That's the parole evidence rule. It states that written contracts take precedence over oral agreements or promises. That's all that is. But you need to know that term and study that term.
Okay.
You need to know what the four the essential elements of a valid contract are and what the three forms of legal consideration are that we just went over as well. Now, what is an amendment and an addenda? When talking about contracts, an amendment is a change. An addenda is an addition. It even has the word add in it, so you can remember it that way. Addenda is when you're adding something to a contract. An amendment is a change. Okay? Just think about politicians. They pass laws and they're constantly changing them. They're adding amendments to them, right? Licensees must not make any changes or additions to the contract after both parties signed it. That would be practicing law without a license. All right, let's do this in the book. You see this here. I wrote some notes on the side. This is the note that I wrote. If you want to copy it in the book there next to amendments and addenda. You could also underline add under addenda. That's an addition showing you that you're adding something to a contract. Amendment is a change to it. But either way, after both parties sign a contract, we can't make any amendments or addendas, add any additions to the contract, because that would be practicing law without a license. If only one person signed, we can make changes still. Have the other person sign and then take back to the original party to initial next to the changes that were made that they didn't originally agree to, so that the contract can continue being valid. Let me know when you got that.
All right, I'm good.
All right, I need 2 seconds. Okay, let me snap it real fast, and then that way I'll finish.
All right.
And then I'll finish when I get off.
Gotcha.
Okay, let's go. Okay.
All right.
Yeah.
So the Real Estate Commission's rules states that licensees follow both contracting law as well as licensing laws. So the REC rules state that for us to be entitled to a commission, a real estate broker cannot be paid unless they have some sort of authorization showing that they were hired and they have that authorization in writing by our client or customer that entitles us to earn a commission. That would be either in a listing agreement, an exclusive buyer's agency agreement, a transaction broker agreement, or between brokerages, it would be a referral agreement to ensure we're getting paid. It has to be signed by the consumer or the other broker. And anytime we sign a contract with a consumer, we must give them a duplicate original. That applies to sales or lease contracts, no matter who the broker's working for. The statute of frauds, this is what we need to know what's in the box here. Statute of frauds states that sales contracts for real estate always have to be in writing in New Jersey. Always, 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 always. You can never have a verbal contract to sell real estate. It's required by law. It has to be in writing. Leases, however, do not. You can have a verbal lease. However, real estate agents, we need to follow the Real Estate Commission's rules and the administrative code. We need to follow state laws and administrative code. And the pertaining to real estate licensees under the administrative code, any contract that we do has to be in writing. They all need to be in writing. We can't, as real estate agents, we cannot have verbal contracts with our clients. It has to be in writing always. Even though contract law in the state allows leases to be, if there's no real estate agent involved, you could have between a tenant and a landlord a verbal lease. It's not a wise thing to do because how do you prove all the terms? So leases must be in writing by law if they're 3 or more years, whether a real estate agent's involved or not. And leases can be recorded if they're in the public record if they're 2 or more years. So this is what you need to know for exam. Sales contracts always need to be in writing. Leases need to be in writing if they're 3 or more years, unless a real estate agent is involved, and then it doesn't matter the length, it always needs to be in writing. And if a lease is longer than 2 years, it can be recorded in the public record. So people can record their long-term interest in the property, putting the world on notice of their interest. So let's highlight the statute of frauds, and then let's make a little notation there that leases longer than 2 years can be recorded. Leases longer than 2 years can be recorded.
Okay, got it.
Okay,
All
good.
right.
Yes.
All right. Excelente. Excelente. Let's see. Where's that? Here we go. All right. So there we go. That one looks like writing and it doesn't need to be script, right? For the
Oh.
note. And it's better than my handwriting. That's a little bit of an improvement, I guess. Leases longer than 2 years can be recorded. All right. I mean, it's always risky to rely on verbal contracts, oral agreements. So even if there's no real estate agent involved, property owners should always be wary of, taking verbal lease contracts. Because how do you prove it in court what the terms are that you and the tenant agreed upon? How much the rent is going to be, when the rent is due, and yada, 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 yada. Then it's he said, she said, right? So contracts, they could be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. These are some terms that we're going to be learning about right now. So let's first highlight them on page 195. Get all these highlights down, if you will.
Yep.
And in express contracts, well, how do we express ourselves? Usually it's by our words. Contracts that are expressed solely by actions rather than words are referred to as implied contracts. Which is clearer, which sends a clearer message? Your words or your actions? I mean, they say actions speak louder than words, but can actions ever be misinterpreted? So implied contracts are demonstrated by your acts and conduct. For instance, a landlord that has a lease with a tenant, and that lease expires, and the tenant did not sign a new lease, but they gave another rent check for the next month to the landlord. If the landlord accepts the check, they physically accept that check from the tenant, it creates the actions of accepting that payment, creates an implied contract in the eyes of the law that the landlord's okay with the tenant being there for the next month. Now, what about all the terms? Is it according to the terms of the previous lease that they had, or is there some other terms? Well, you see, that's why it leaves some things to interpretation and it's not so clear. But if we had everything in writing and they signed a new contract, then it would be an express contract. This is why it's always in the best interest to have it in writing, to express those terms and show their intentions in words, not solely by actions. Okay, bilateral contract, both parties promise to do something, and the litmus test to determine if something's a bilateral contract would be this statement that says, I will do this and you're going to do that, okay? If you could apply that statement to your situation, it's a bilateral contract. Whereas a unilateral contract, on the other hand, is a one-sided agreement or promise. Now, let's highlight the definition here, although this definition may get your head, boggle your mind a little bit. Let me read it and you'll see. A unilateral contract, on the other hand, is a one-sided agreement where one party makes a promise to induce a second party to do something. The second party is not legally obligated to act. However, if the second party does comply, the first party is obligated to keep the promise. See what I mean? You guys got the highlight down? I'll turn the slide and you could, I'll give a better definition for you.
Yeah, I
Got
got
it.
it.
All right.
Okay.
So here, an implied contract is, okay, so let's look at my definitions here for express, implied, and then we'll go over the unilateral, the bilateral, unilateral. So I have my own definitions for these things here. Express contract, lay out all the terms, expressing them in words, leaving nothing to interpretation. Those words are usually in writing. An implied contract is created by one's actions rather than their words, and it's demonstrated by their acts and conduct rather than words. Therefore, it may leave some things to interpretation and cause confusion. Like a lease expires, but the landlord accepts the rent. There's no contract in writing. Or if a bank accepts a payment from an owner after the foreclosure process begins. It could be interpreted by the courts that there's some sort of an agreement between the lender and the owner for an alternate form of repayment to get caught up on the outstanding balance. So therefore, they're not going to be able to move forward with a foreclosure process. That's why banks will usually not accept any form of payment from somebody who's being foreclosed on it unless they could afford to pay the full amount that is outstanding. Unilateral contract, let's get to that definition. I had the better definition here. A contract where one party is required to do something, but only if the other party acts, but they're not required to. Okay, so I use the word party a lot less to explain the same thing as the book did, right? How many times did they use the word party? Party, 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 party. One party to the other party to the other party, and you're like, what? Let me read that again. What did I just read? So it's a contract where one party is required to do something, but only if the other party acts, but they don't have to. So for an example, let's just say a law enforcement agency offers a monetary reward if you aid in the capture of a criminal. Are you required to aid in the capture of the criminal? No. But if you do, are they required to pay you the reward? Yes. So they're not required to pay you the reward, though, unless you aid in that capture. That's basically what they're explaining. So any contract where one party has an obligation to perform and the other has an option, that is a unilateral contract. Unilateral contracts have options for people, and option agreements must be prepared by attorneys. We cannot prepare option contracts. That would be practicing law without a license. So the unilateral, so the test to see if something is a unilateral contract or not would be a statement like, I will do this if you will do that. Whereas the litmus test for a bilateral contract is, I will do this and you will do that. If and, that's the difference. Now, contracts can be executed. That means that they can be fully carried out and everything is done. Well, that's really called a fully executed contract. Usually when we use the term executed contract, it means a signed contract. Have you executed the contract yet? What did I ask? I asked if you signed it. Now, the term fully executed has two meanings. It could mean that the contract's been signed by everybody, or it can mean that all the terms have been completely carried out and fulfilled and there's nothing left to be done. Whereas the term executory also talks to the status of the contract. Tory meaning still in progress in Latin. So it means that all of the terms have not been completely fulfilled. There are still things that need to be done. So let me ask you, did your client execute the contract yet? What did I ask?
Did they sign the contract?
Okay, so then so they signed the contract. So now we have a fully executed contract, meaning signed by both parties.
Yes.
So what status is the contract in now at this point, if it's just been signed by both parties?
The beginning,
So you mean that there's still things that need to be done in the contract? So what status is that? That's called executory status.
Okay.
okay. Okay.
Now, if everything that the contract required us to do, home inspections, appraisals, this, that, and the other thing, and we're all done, we're just waiting to close, well, now the contract's been fully executed.
Okay.
Okay, so fully executed, the second definition here pertains to the status of the contract, just like the word executory. And I rarely, if ever, hear anybody use them to describe the status of a contract. But usually we use the term executed or fully executed a lot, and that's usually pertaining to signatures, whether it's attorneys or real estate agents. Usually when we throw around the term executed or fully executed, we're talking about, was a contract signed? Was it signed by everybody? So let's highlight an executed contract can be signed contract. A fully executed contract would be one that had been signed by all parties. That's on page 196. Second paragraph, page 196.
Okay, got it.
Okay.
Yep.
Dooby-dooby-doo.
Yep.
Boo, 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 boo. Boo, 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 boo. All right. All right. Whoop. Move it. Move it. Here we go. And then we have to insert a little shape over here. I'm going to be like Bob Ross, putting you to sleep with my explanations here. And we're going to draw a little smiley face. We're going to put a bush right here, a happy little tree. And then we're going to give him a friend.
Oh.
Actually, no fill. There we go. That's how we do that. And then all right. Good enough. All right. Now, contracts can be valid, void, voidable, or unenforceable. So what do these terms mean? What do they mean? Well, a valid contract is one that has all the essential elements. And what are the 4 essential elements of a valid contract? Competent parties, offer and acceptance,
The legal part, right? Has to be legal.
all right, and what else?
Consideration.
There has to be some form of consideration given between the parties, right? So, competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. So, if it has all of them, then the contract is a valid, fully enforceable contract. Now, contracts that are void, well, void contracts are a self-contradictory term because a void contract isn't a contract at all. It's one that's missing one of the essential elements. Then we have voidable contracts are ones that can be canceled or rescinded by one of the parties. Like I'll give you a couple examples on the coming slide, but one example that we have highlighted here, which is probably one that you'll get on exam, is an example is with a contract with a minor. You cannot enforce a contract against a minor because they're not a competent party. However, if you do sign a contract and enter into a contract with a minor, they can enforce the contract against the adult because the adult is a competent party. So can you enter a contract with a minor? Sure you can. It's pretty stupid because it's a one-sided agreement then, because you can enforce you can't enforce the contract against the minor, but they can enforce it against you. So what's the point?
Mm-hmm.
And then an unenforceable contract is one that also seems on the surface to be valid, but however, neither party can sue to force performance because neither party was a competent party at the time that they signed it. Like if you got two people that they're fall down drunk and they sign a contract, an agreement, is that legally binding in a court of law? No, because neither one of them was a competent party. They were both under the influence. So neither one was a competent party. You can't enforce a contract against somebody who signed it when they were drunk or high or incompetent, not of sound mind. They have Alzheimer's, dementia, right? You can't enforce a contract against these people. They're not of sound mind. You guys got these highlights down?
Yes.
So here's my slide that gets into that, explaining the valid, voidable, unenforceable void, and also goes over duress and undue influence. So in mine, I say a valid contract meets all the legal requirements to be enforceable. A voidable contract can be disaffirmed by one of the parties. It may be missing one of the essential elements to be voidable. Or it could be a contract with a minor. It's voidable by the child. Or if somebody's under the influence of drugs or alcohol, or if they're not of sound mind. You also can't take advantage of somebody and have them sign contracts with undue influence. That means you took advantage of them. Or maybe they were under duress, under force or intimidation, or great stress at the time. Although if they're under great stress at the time, that could be considered duress, but it could also be considered undue influence. They thought they were going to die and they were on their deathbed, so they gave away everything they owned, right?
Yeah.
Yeah.
So let's highlight under duress means force and undue influence means being taken advantage of on page 196.
Got it.
You got to be very careful when dealing with elderly people when getting listings, signing contracts. Treat them respectfully. But you got to realize that sometimes people that are old can have Alzheimer's or experience dementia. So they're not really of sound mind, even though they may seem like they are. They could seem like they're sharp as a tack, sharper than some of your younger friends, but yet they think they're living in 1920. I mean, it's a weird thing, these Alzheimer and dementia. It's not, sometimes you could see that people are grasping their words. They can't remember things and then they just give up on them. Kind of like Joe Biden's speeches. I had to do it. I had to do it. But you get the idea, where they start
wait for it.
And losing the word that they're trying to say, so that they're just like, anyway, or it could be a situation where they're sharp as a tack. They have all their words. They're not grasping for anything, but they think they're living in a different time. Or they're speaking to you and they forget the fact that you are their daughter. So they don't even know who they're talking to. So when signing contracts with people like that, you got to use extreme caution because you don't know what's going on in someone's head. You don't know if they have Alzheimer's, dementia, or some other mental disease or defect, right? So you got to be careful. What I like to do when I'm dealing with elder people, treat them with respect. But what I usually like to do when I go in for listing agreements with them, I mean, I always check the tax records first and I see if there's other owners on there or not. And even if I see there's nobody else listed as the owner and this person's the only one I'm meeting with, I'll ask them, is there anybody else that needs to be signing contracts with us here today?
Okay.
You know, because sometimes I could stir something up. Maybe they have like a child or someone else who's their power of has a power of attorney over them, or they need to sign contracts with, you know, for legal matters. And sometimes they know it and they could recall it if you ask the question. But then again, they may not, you know, but we should still ask. So this is the approach that I've taken. So because I've come across this issue several times when dealing with elder people. So I ask them, is there anybody else that needs to be signing contracts with us here today? I actually had one lady, she was really sharp when I said that. She looked at me and she was like, what are you trying to say? Trying to say I'm losing my marbles? I was like, no, nothing like that. I was just, is there anybody else, like any other owners on the property that own it with you that need to sign a contract? You know, played it off, you know. But yeah, she caught me. She caught me red-handed. That's exactly what I was asking, you know. But you could still play it off in a way, like, oh no, I just need to know, are there any other owners that need to sign? You know. So. So what do you do actually if that happens? What if you do? Because I actually had this situation happen to me once where I signed a listing agreement and I got a listing from an older lady. She interviewed a couple of real estate agents and she'd get back to me. She got back to me. She said she's giving me the listing. And I was like, great. I filled all the paperwork out, met with her again, took pictures, all that stuff, put the listing in the MLS. A couple of days later, I get a call from some lady saying, yeah, I went to my mom's house and she had all this paperwork on her table from real estate agents from different companies. And I asked her what's going on here. And she said she was interviewing real estate agents and that she listed her property for sale with you. She's like, my mom's not selling her property. My mom's got dementia and I'm her legal guardian.
Oh my God.
So what do I do now? I already put the listing in MLS. What do I do?
I mean, isn't it null and void now? It would be considered.
Go with that old Ronald Reagan adage, trust but verify. I don't know who the hell this lady is that just called me up. Right? I don't know who she is. I mean,
right.
Is she really the daughter or is she a real estate agent trying to cancel a listing so she could get it, you know?
Yeah, that's true.
Or maybe she is a legit daughter, but does she have the legal right to manage her mother's affairs? You know, so I'm going to tell her, and this is what I did tell her. I was like, okay, well, if you're the legal guardian, you should have some sort of paperwork from the court that says that you're in charge of her affairs. I'm just going to need you to come down to our office with a copy of that paperwork so that I could add it to our files. And I'm going to need you to sign the release of the listing so that we could remove it. Otherwise, I got to keep looking out for my client's best interest and continue trying to market and sell the property. But if you're the legal guardian, you should have some kind of evidence to that. I'm going to need to see that. And we're going to need to have you sign the contract because the MLS will find me and they won't allow me to take the listing out of the MLS unless you unless the person, the owner signs it. And if you're the one that's the legal guardian and has that right, well, then that'll be you. Okay. And I'm going to need that paperwork too. And then this way I can at least explain it to the MLS what happened. Okay. And that's what I ended up doing. And she was the legit person. But I had another instance like that with an older gentleman in Colonia. And he was interesting character. He was a funny guy, but he was kind of shaky. You know, sometimes you get old people, they're a little shaky. He was kind of like shaky, like his hands would just shake, you know. And but he was active and he was running around. He seemed a real nice guy to talk to. And so I'm listing the property for sale with them, and I asked him, because of my previous experience, I said, is there anybody else that needs to sign contracts with us here today? And he was like, oh yeah, thanks for reminding me. Oh my gosh. He's like, yeah, my son, let me call him. He just lives around the corner. He'll be right here. He's like, it's crazy. He's like, when they're younger, you're taking care of them. And as you age, pretty soon the tables turn and they're taking care of you. I was like, okay, I understand. So we waited for him to come, and yeah, he had to sign the contract with his son because his son was now a legal guardian. So anything his father did, he had to sign paperwork, but the son had to sign it too because he was the legal guardian. So that we had them both sign the contracts and to list the property for sale. But see, I stirred something in his mind and his memory, and he was able to do the recall. Now, there's no guarantee that that's always going to happen, but I was lucky with this guy that I was able to stir that up and make sure. Now I got everybody on board and signed the paperwork. But that's not guaranteed to always work. But hey, learn from my thing and what I did and give it a try, give it a go. All right, so some other things coming up: performance of a contract and learning that dates are merely guides to follow in contracts. We're going to learn about the phrase time is of the essence. And we're going to learn about different ways to discharge a contract and how a contract can be discharged. We're going to learn the term default or breach of contract. And we're going to learn about statutes of limitations in New Jersey and what that term actually means and what those time periods are. But we're going to learn about them tomorrow. It's going to be continued because we're already at that time at the end of the day today. So we will continue chapter 11 in the next recording tomorrow.
Okay.